Hello, my name is Lara Akinlud, and I'm the managing attorney at Larhdel Law. One of the most important and most misunderstood questions in an E2 visa application is this: have you truly invested, or are you still only in the process of investing? That distinction may sound subtle, but from an immigration officer's perspective, it can be the difference between approval and refusal. Many E2 investors believe that having money available or planning to invest is enough. But under E2 law, intent alone is not sufficient. Officers are trained to look for clear evidence of commitment, not just preparation. 1. What truly invested means to an officer. When officers assess whether you've truly invested, they ask, has this investor already committed funds in a meaningful and irreversible way? They look for evidence such as funds already spent on the business, signed leases or contracts, equipment or inventory purchases, marketing and operational expenses, professional fees already paid. In simple terms, the money must be at risk. If the business fails, the investor must stand to lose something real. 2. What in the process of investing actually means. E2 regulations do allow investors to apply while in the process of investing, but this is often misunderstood. Being in the process does not mean money sitting untouched in a personal account, vague plans or unsigned agreements, conditional steps that may never happen. Instead, officers expect to see funds placed in escrow with clear release conditions, binding contracts that activate upon approval, a near complete business setup ready to launch. The process must be active, documented, and credible. 3. Common mistakes that lead to refusals. One of the most common refusal reasons we see is investors who invest too little too late, delay committing funds until after approval, rely on explanations instead of evidence. From an officer's perspective, this raises a serious question. If the investor isn't willing to commit now, why should the visa be approved? 4. Timing and structure matter. There is no universal dollar amount for an E2 investment. What matters is proportionality to the business timing of the expenditure. Whether the investment demonstrates real commitment, two investors can spend the same amount and one can be approved while the other is refused, based entirely on how and when the funds were committed. 5. Why legal strategy is essential. This is not an area where guesswork is safe. A well structured E2 case shows officers that the investor understands the risk, the business is ready to operate, the investment is genuine, substantial, and committed. At Larhdel Law, we help investors structure their investments in a way that aligns with how officers actually evaluate E2 cases, not how investors assume they do. So, have you truly invested or are you still in the process? The answer must be clear, documented, and defensible. If you're unsure whether your current investment level meets E2 requirements, or you're planning your next steps and want to avoid costly delays or refusals, it's wise to get legal guidance before moving forward. If you'd like to discuss your specific situation, you're welcome to schedule a consultation with our team at Larhdel Law, and we'll help you assess where you stand and how best to proceed. Thank you for watching, and I look forward to helping you move forward with clarity and confidence.